In this video, we're going to take a closer look at another threshold standard for obtaining a United States patent. That is the concept of non-obviousness. Now, obviousness is one of the more complicated concepts in patent law. When we're talking about obviousness, we're talking about even if your invention is new. In other words, even if there's no single piece of prior art that teaches each and every element of your eventual claims for your invention, is the difference between your invention and the prior art in its entirety enough that you should be awarded patent rights? Now, there's two important aspects to obviousness to keep in mind. The first is that when we're judging whether an invention is non-obvious and therefore deserving of patent protection, we judge that invention from the vantage point of a person of ordinary skill in the art at the time the invention was made. This means, who is a person that's generally familiar with this technology and would understand the basic concepts in the field? And from the vantage point of that person, at the time the potential patentee came up with the invention, is that invention non-obvious? The second aspect of obviousness to keep in mind is that, unlike novelty or anticipation, where we're looking for just one piece of prior art that teaches each and every element of your eventual claim, with obviousness, you're looking at the prior art as a whole. So you're able to combine the teachings of various prior art references in order to determine whether this potential invention is in fact non-obvious and therefore deserving of patent rights. Now, the Patent and Trademark Office has given us a number of examples of situations where an examiner should find that a particular technological innovation is obvious. One example is where you're just piecing together known elements from the prior art using known methods in order to achieve a result that's predictable. Another example of an obvious innovation is where you're simply substituting one element for another to achieve a predictable result. And just another example of this list of criteria for finding innovation to be obvious from the Patent and Trademark Office is where it would be obvious to try your contemplated invention. In other words, there's a finite number of ways to do something, and you have chosen one of this finite number of ways to solve a problem, and it would be predictable or generally known in the field that that solution would work. Now, it used to be the case that if you're going to combine two prior art references, like the safety razor blade with just two blades and the cutting technology from the woodworking field, that there had to be some teaching, suggestion, or motivation to combine those references. So the examiner or someone challenging your patent would have to point to some evidence, probably within those two references, why it would be obvious for someone in the field to take those two teachings, combine them to solve the problem you were trying to solve. But the law changed in 2007, and you no longer have to have that express teaching, suggestion, or motivation to combine. The test for obviousness is more one of common sense. And generally speaking, we're looking at predictability. Would it have been predictable to a person in this field that your solution would work? Now, as you can hopefully appreciate, obviousness is almost always a relevant question when you're trying to determine whether your invention is in fact patentable. It's very easy for one to find pieces of prior art and piece them together to show something close to your innovation that you're trying to patent. So if you're trying to demonstrate that your invention is in fact patentable and therefore is in fact non-obvious, it's helpful to be able to point to pieces of evidence that show that it'd be unpredictable to those familiar with your field that this solution to the problem would actually work. In fact, courts have pointed to certain pieces of evidence that they call secondary considerations that someone trying to get a patent can point to try to rebut an argument from someone else that their invention is obvious. These secondary considerations include the commercial success of your product. If you have products or services on the market that actually embody your invention, then you can point to that commercial success to say, if my invention was so obvious, why would people be buying it the way they are? Another piece of evidence that can be used to show your invention is non-obvious is the long-felt need. So if this problem has existed for a long time, but no one has solved it, it would also tend to show that your solution to that problem is non-obvious and therefore patentable. The failure of others is also relevant to the question of obviousness. If other smart people have been trying to solve this problem but have failed to do so, and then you came along and solved the problem, that would tend to show that your invention is non-obvious. Anything else that would tend to show that it would be unpredictable to those in the field that this combination of elements would actually work to solve the problem you're trying to solve is helpful. And it's also helpful if you can point to concrete evidence. You're not just arguing anecdotes to the patent examiner or to a court, but you can point to other pieces of evidence, other publications in the field that support these arguments. That's going to help to show that your invention was unpredictable and therefore non-obvious. This is a very general overview of the law of obviousness as it relates to patents in the United States.